perhaps even extending permissions and allowing permissions to be extended. For my money, just abolish Section 73, subsection 5, which never worked. It's never been a clever idea, and would allow authorities to grant Section 73s to extend the life of consents in the way they were doing before 2006. And for reasons that I simply don't understand, that the then government thought it was a good idea to get rid of that power. There's been a number of letters that have been sent in to the Minister. His inbox must be quite high now, from such august bodies as the City of London Law Society, Planning and Environmental Law Committee, the London Property Alliance, all suggesting that we bring forward reforms to try and get us through this emergency period of time. The one thing that I would want to flag up is SIL, and the desirability of somehow bringing some sort of relaxation with regards to the payments of SIL and phasing payments. SIL at the moment is horribly inflexible, and there's a desperate need for that to happen. The courts have been flexible. I've had the experience of a Section 288 administrative court challenge that was heard by telephone 3 weeks ago. The decision came through yesterday. The order was made yesterday, and I came second. Disappointing, I have to say, but could have been worse. But the point is that the courts worked, and we did it all remotely because there was a will there. The Planning Inspectorate have been bombarded with requests to resurrect the appeal system in terms of hearings and inquiries. We're told that there will be pilots next month under pressure from our professional organisation, PIBA, and PINS are reporting in CMCs that they will be bringing that all forward. It's fair to say it's disappointingly slow, and I hope that we all will see some progress with that. And then one final thing that's caught my eye, Charlie, is ONS, God bless them, have, well, they should be thanked for publishing the controversial 2018 household projections during this difficult time, because it creates the promise of many happy hours at examination, arguing what the figures are going to be again, many happy hours at Section 78, and gratefully they're utterly hopeless, it would seem, and therefore providing work for the planning bar. So thank you to ONS from that. Thanks, Paul. Any comments to the panel? Mary, what's your take on all this?
I think they're all great points, and I think on a more serious note, there are two really important things which I think government is really thinking and trying to grapple with at the moment. And I would urge anybody with examples of the difficulties that these issues are causing you to make sure that you advance those examples, whether it's to your local HBF representative or whether it's to the British Property Federation. I think government is in listening mode, and they particularly want to hear from you if you have issues with relation to SIL and mothballing sites. And if you're able to mothball a site, well, then you're a lot luckier than those who are already on site, making payments, receiving notices, and who can't, on the face of it, escape that liability. The other thing that they're really seriously looking at is the expiry of planning permissions and the whole question of implementation, which has become extraordinarily difficult. So again, if you've got examples that you can draw to government's attention, I would urge you to do that, because, as I say, they're in listening mode.
Thanks, Mary. We've got a few questions coming in the Q&A. Simon Knight from Waits asks, is that my typical wardrobe? Well, Simon, no, it's not. This is what happens when you don't get any ironing done for 3 weeks. You have to look at your reserves. If we'd been 2 days later, we would have been into some even more extreme attire, I tell you. So let's hope I get some ironing done before this time next week. Robert Fort from Gerald Eve, you've asked, is bringing back Section 106 BAs a good idea? Really harking back. Well, in my view, yes, it is. There'll be a bit of attention, perhaps the direction of travel from government and RICS in terms of viability assessments. I'm not sure it's likely to happen, but obviously that was the solution last time we were in a profound crisis and things slowed down. Be interested to see whether that kind of idea is progressed. Well, without further ado, let's move on to planning court casework. Mary, what's been going on in the planning court recently?
Well, the case I've singled out is a case called Adverse, and this is a story about a High Court challenge to the grant of an outline planning permission, which was issued in May 2019 following a November 2017 resolution to grant. And it's rather more than the usual story about an inadequate officer report unwittingly causing delay to the delivery of housing through allowing in a planning challenge. this concerned an allocated site, and that's very important because it was very significant to the final result. The court found that the first ground of the challenge was made out, and that was that the report, the officer report, significantly misled councillors on a material matter. You will all recall that that is a key ground. And in this case, the officer report failed to meet what the court described as the bare minimum standard by inadequately grappling with and addressing what was then in the MPPF 12, paragraph 134. You'll know now that that's 196, the Keeneys amongst you. And that deals with where a development causes less than substantial harm to the significance of a designated heritage asset. That harm has to be weighed against the public benefit of any proposal. And the court found that the officer's report should have explained the extent of the harm, and they should have weighed that harm against the public benefit, and that the failure to do so was materially misleading, and so that ground was made out. And a similar criticism was also made in respect of a listed building under Section 66. However, as some of you may well recall, the court retains a discretion under Section 32 of the Senior Courts Act not to quash decisions if it appears that the outcome of the decision from the applicant's point of view would have been the same. So having succeeded on the face of it on ground one, it must have been something of a bitter blow to the applicant that the judge actually found that absent the flawed officer's report, the councillors would have reached exactly the same conclusion and therefore refused to allow relief. And interestingly, the judge relied very largely on the fact that this was an allocated site, and that at the time of the local plan examination, the examination inspector had clearly himself had to weigh the benefits against the identified less than substantial harm to the very same heritage assets, and had clearly found that the public benefits outweighed the harm. So on that basis, the court declined to quash the permission. So I think that's a very interesting and slightly unusual case where the ground was made out, but the court didn't quash. And the other thing to say is that there was a second ground, and this was about an alleged difference between the policy approach in the MPPF 2012 to major development in the AOMB versus the policy approach in the later 2018 and 2019 MPPFs. Now that ground failed, but one of the interesting things the judge said in relation to that issue was that the decision maker, both at the stage, the local plan stage, the outline application stage, and finally the looking to the future, the reserve matters stage, would need to consider the development against the major development tests at each stage, and that therefore the matter would need to be looked at again in terms of moderating any harm to the AOMB at the reserve matters stage. So I think that just is an interesting reminder that actually, whether it's designated heritage assets or in this case the AOMB, you need to look at those issues at the local plan examination stage, then again at an outline stage or a detailed application stage / reserve matters stage. So interesting.
Thanks, Mary. I mean, arguably generous in terms of the judge's approach to discretion, having found there was no error of law. Chris, what do you make of it?
Yeah, I mean, I think it was very generous by the judge, but it's all well reasoned, and he's explained that. I think that really here we see it again with an officer's report not handling the heritage issue well. And if ever there's an area where the council should ask the legal team, the solicitor in the council, or maybe going to external advice, it is on this heritage issue. So what the judge said at paragraph 20 was that the officer really hadn't assessed the significance of the conservation area or the impact of the significance on the conservation area, and that even though they tried really hard to say it was in the report, the judge was having none of it. But you know, in fairness to Christopher Kitkowski, or Kit Kat, as we sometimes know him. He did a fantastic job in persuading the judge to look beyond the report. And as Mary said, look at the wider context. That really is skilled advocacy, I think, on his part.
Yeah.
And also, it does flag up, we're often asked the question about the role of interested parties in 288s and JRs, and I think it provides a pretty emphatic answer that sometimes they can play a seminal role in the outcome of such proceedings.
Yeah, absolutely.
Yeah.
Thanks, Sasha. Got a few more comments coming in through the questions. Some comments about pins. We're going to come on to them a little bit later. And Jonathan Easton has very generously offered to lend some hair clippers to Chris and me, which is to say, Chris and I have a deal, a bet in place as to whether I can morph into John Bon Jovi more quickly than he can morph into Ole Gunnar Solskjaer. I think it's probably about a score draw at the moment, hair-wise. We'll update on that one next week. So we're moving from the planning court to the planning inspectorate and MHCLG appeal decisions. There's been quite a few big decisions in the last few days, including one that's come out today, which we'll probably talk about next week. But the one we're going to discuss now is the Seashell Trust Greenbelt case, where the Secretary of State found there were very special circumstances. Paul acted for the successful appellant in this one, so there's absolutely no way we're going to let Paul lead on this and wallow in his own glory. So we're going to chuck that one over to Chris and tell us a bit more about that case.
Okay, well, Paul is pleased, obviously. This is a decision that came out yesterday, and that's why he's still smiling. Okay, it won't be all weekend. But the point is, I've chosen this for Appeal of the Week because I think it's so significant about what the Secretary of State is thinking at the moment. We're all having a few negative decisions from inspectors, but the Secretary of State has been on a very, very positive journey of the last couple of days. And I don't mean the journey to his house in Herefordshire and his parents in Shropshire, obviously. I don't mean that, but I mean the journey he's on in granting lots and lots of planning permissions. It's incredibly encouraging. And just to set this case in context, just cast your mind back to November last year and a decision in Burley and Wharfdale in Bradford. And in that case, a positive recommendation for 500 houses in the Greenbelt because Bradford weren't getting on with their plan. And the Secretary of State firmly rejects it and says, no, I'm not granting planning permission. Just bring it forward 6 months to where we are now. And what do you see? You see the Secretary of State taking a positive recommendation in Paul's case and granting planning permission for, wait for it, 325 houses in the Greenbelt. Now, it was also for the redevelopment of a school site, but those houses in the Greenbelt were on undeveloped open land. And what's really interesting is that the inspector acknowledges the harm is significant. He acknowledges it's inappropriate development. Obviously, I'm sure Paul just had to accept that inevitably, but he finds harm to openness and he finds significant encroachment, the inspector, into the countryside, which was obvious, really, for that scale of development. And yet, when it came to it, the Secretary of State, following the inspector's lead, granted planning permission. Now, what's really interesting is to look at the very special circumstances that got Paul's client over the line. They're a charity, and they were redeveloping a school for children with special needs, multiple and complex needs. And obviously, you know, that is going to be a very positive aspect. But that doesn't really justify all those houses. And indeed, Paul's clients didn't want to deliver the 50% affordable housing that the core strategy required. And in the very special circumstances that the Secretary of State accepted, he places very significant weight on the affordable housing offer, even though it's below a policy level. The inspector deals with it in a sophisticated way. He says that the policy is out of date, it's from the core strategy, and the core strategy hadn't been subject to viability testing as required now. The core strategy was from 2011. This is in Stockport, by the way. I should have perhaps mentioned that at the start. For those in London, that's near Manchester. And it is...
Oi, oi, oi.
Right, yeah, didn't think I'd get away with that. And the reality is that even though it's below the policy level, very significant way. And then the council's supply was a maximum of 2.8 years. So nearly half what it should be. This is mirrored all around Manchester because they haven't made progress with their spatial framework plan, and as the Greater Manchester Spatial Framework, and as a consequence, nearly all the authorities around Manchester don't have a healthy supply. But if they're in the Greenbelt, they've probably been sitting back and thinking, well, you know, appellants, developers, do your worst. Well, here, an appellant has one in the Greenbelt, and again, the Secretary of State gives very significant weight to that housing need case. So the housing need case was a major part of the very special circumstance case. And well done to Paul, ably assisted by Giles Cannett. The case has taken so long that Giles now has to be recorded as a silk, even though he wasn't at the start of the process, and Anthony Gill as well. A great, great result.
Shall we let him comment on his own victory? Go on then.
Go on.
Yeah, just on a note of seriousness, this is a failure of the development plan system, more importantly. Stockport's core strategy was 2011. At that stage, the Seashell Trust was transforming from what was then the Manchester School of the Deaf through to what's now a school dealing with really the most vulnerable children in our society in terms of their level of disability, dealt with through the charitable sector rather than the state sector, curiously. But there was a desperate need for this redevelopment to bring the school forward, and they're just solely based upon charitable functions. They went through the process of plan preparation. They objected. They sought to get it in the local plan that went nowhere in Stockport. They got an allocation in the draft GMSF. Then they wait another year and get another allocation in the next version of the draft GMSF. No doubt they'll get an allocation in the next version of the draft GMSF. But if we had a development plan system that was fit for purpose, this site would have been allocated years and years ago. As it was, a charity that does some of the most extraordinary work that I've ever seen in my life had to go through the joy and fun of a 6-week inquiry, spending time criticising the case being run by the council and ultimately succeeding and sitting there for a 4-year process to get their consent. What I would say though, and I'd stress for anybody to read, I think it's paragraph 596 onward of the decision, is it's a real triumph for the forensic process, because we won from testing the evidence that was being thrown against us, and our evidence withstood that test, and we were able to demonstrate the flaws in the council's case. It demonstrates why inquiries work.
Can I say something about what Chris said, Charlie?
Yeah, go for it.
What Chris said about the current Secretary of State, I think, is arguably proportionally the most pro-housing that we've had for a very, very long time. And Chris, not only this decision, but we know from Long Melford last week, we're in a climate where actually, do you remember that we all remember the days when clients feared call-ins, but from a developer's point of view, call-in now almost is a likelihood of getting consent in the current climate, which will probably only get stronger with the COVID-19 consequences. So we should all note we have a very pro-development Secretary of State currently based on the decisions he's granting.
Yeah.
So big is beautiful.
Absolutely. Well, often it's for ESC, isn't it, that the larger the development, the greater the very special circumstances case is. I had no involvement with this case, but I felt I did an inquiry the week before you started it, Paul, against Giles Canuck, where I was calling Nick Lee. I see actually a list of people, both of them are there, so hello to both of you. And I think they were both seeing the inquiry that we were doing that week as a sort of warm-up for the big event the following week. And it's actually reminded me that Nick and I won the pub quiz in the local pub in Buxton where we did that inquiry. And somewhere in this room, I've still got the voucher for £20 of free beer in the local pub in Buxton. So whenever I go back...
Just on Giles's behalf, Charlie, what was the result in that case?
Ask Giles. I came second, close second. Let's move on. And... we've got, actually, before we do, I just wanted to, before we move on to LPA decisions, there's one further planning appeal I just wanted to touch upon briefly, which was an appeal decision by Christina Downs in Wokingham, where she knocked off some of the 5-year supply due to concerns of the delay that COVID-19 crisis we're all currently going through could have on the delivery of housing. Didn't seem to be a central feature of her decision, but she knocked off an element of supply, and I think that's likely to be the first of a number of cases where that issue is developed. I mean, it seems to me that it's at least questionable whether it should be knocked off a 5-year supply that's measured from a base date of April 2019, because I've always taken the view that in that situation, the question is, was that site deliverable as of the base date? And though it may be permissible to take into account evidence after the base date to answer that question, the question is still always, was it deliverable as of the 1st of April 2019? And as of that date, COVID was still a problem for bats. But plainly, it's a material consideration. Plainly, it'll be relevant to subsequent years, and it's going to be interesting to see what local authorities do. Did they develop action plans to deal with this? There's a glimmer of hope on LinkedIn today from the LPDF indicating that some developers are starting to reopen or consider reopening their stalled sites, but there clearly has been a period of delay, and I think that's likely to be a topical issue going forward.
Charlie, can I say, I think next week we should debate, it's worth debating the question of, will COVID-19 have an effect of reducing requirements?
Yes.
Or will it have the effect of increasing requirements? Well, not changing the equation, whether the government will take a hawkish or dovish approach to housing, land supply and delivery. And I personally think we should discuss that next week.
And it's also the case, isn't it, that local authorities who already now have to pay a greater attention to demonstrating deliverability, will have to factor in COVID-19, and those that don't will be exposing their underbellies a bit to the likes of us lot.
Indeed. I think the critical thing is not only to deal with it head on, but to be seen to deal with it head on. So to have some kind of strategy in place that you can wave before an inspector saying, we're actually dealing with this. But no, Sasha, completely agree. And it's interesting that only this afternoon, Planning Magazine Online was reporting that South Oxfordshire have written to the Secretary of State asking for a relaxation of their housing and supply requirement. Not so much the requirement figure, but the requirement for a 5-year housing and supply due to the pressures of COVID. And it's very interesting.
Charlie, can I say, as a ratepayer in South Oxfordshire, I know you, Chris and me have all made a good living in the past 3 years because of South Oxfordshire's problems with HLS, but I speak as a ratepayer and I hope they rectify the situation soon.
Guy Wakefield, who's on this, I can see, well, no, I'm very popular in your neighbourhood, in Chinner in particular, Sasha, with let's move on to local authority decisions and a brief discussion on what's been coming forward at local authority level. And Sasha, you're going to help us with that. Well,
I am, because I think we've all reflected on this, both whatever perspective we have, whether we work for LPAs or the development industry. And one of the interesting things from our perspective has been how different authorities have reacted to the unprecedented events of the past 7-8 weeks. And it is noteworthy how some authorities are still wrestling with decisions, others are being more proactive. And I thought worth a particular mention was Waltham Forest, who quite early on the 2nd of April, determined a very large scheme of 750 units. And they determined it in a manner which I think is almost certainly lawful, which were having the councillors dealing with safeguarding distances and having officers come through in the same way we're speaking today through video conferencing. And in that case, they were able to determine a very, very large application in the current context without a hitch. They didn't face the problems of South Somerset. And I commend Waltham Forest for taking on with bravery pretty early on in the lockdown a decision of that magnitude and granting consent in a pretty quick time.
To be fair to South Somerset, it wasn't just them, but I think was one of the ministers in Wales got into trouble on Zoom yesterday, didn't he, for speaking in somewhat forthright terms about the quality of one of his questions. Paul, what's your take on the Waltham Forest example and other local authority activities in recent days?
Yeah, I think it's remarkable how quickly a change in the legislation results in a change in culture. I appreciate authorities are struggling for a whole host of reasons. Staff have been taken off planning and put onto other areas that we, of course, commend. So it's remarkable that there are a number of authorities that are putting their head above the parapet and recognising that planning is still key to the economic and social well-being of the area, and therefore it needs to get the requisite priority. I also would say fair play to the very many councillors who are no doubt grappling with the technology in the way that we have for the last 2 or 3 weeks, in a way that may be rather more uncomfortable to your average Shire-born councillor. So I think that there are many things that need a pat on the back. There are, as South Somerset has demonstrated, still some teething problems with that. So far in this
I
call,
agree.
none.
Mary, do you want to add something there?
Yeah, no, I agree. I mean, as we speak, my local council, Wandsworth, is having a virtual meeting right now, and one of our projects has just, they've resolved to grant a planning consent. So, you know, I salute the councils that are getting on with it. And even those who have not yet commenced having virtual meetings are all grappling with how they want to conduct themselves in the future. Should they have some councillors actually in situ? Should they have everybody at home? The schemes of delegation are all getting a dust down. The sort of management options are all being revisited. And I actually think there will be some long-lasting benefits as a result of the new technology that we are all experiencing and using more, even though it does seem that some are quicker than others.
How many Zoom shares did you buy last week, Mary?
I would just throw in though, Mary. It's absolutely right to commend planning committees, but with planning committees, we're probably dealing with a dozen and a half people that are involved in them. What's going to prove difficult and perhaps needs a bit more thought from government, again, whilst they're in legislating mood, is how you deal with full council meetings. For the development plan process to come forward, they tend to be policy that requires a full council. And all of us that have stood in front of a full council, imagine the dozens and dozens and dozens of people in different locations and how you marshal that. Certainly that needs some thought, because what would be really unfortunate is if all that gets pushed off until such time as this business is over.
Indeed, and I'm sure. I mean, also, if you just think about every year, councils have to have very important meetings, finance meetings. So I'm sure these things will be looked at.
Absolutely. Let's move on to praise of the week. And Paul, it links in quite well with what we've been discussing, really, doesn't it?
Yeah, it does. So those of us that act for the development industry, as well as the local planning authority side of things, public and private sector, sometimes it's all too easy to focus upon where you're being critical of councils. And so I noticed last week that 6 authorities were identified as being at risk of special measures as a result of appeal failures. What that actually means is that everybody else isn't. And what it means when you drill down into the figures is that of the 300 odd organisations with planning powers, 70% of major applications from those 300 organisations were dealt with within 13 weeks, and over 170 of those organisations dealt with 90% of their major applications within 13 weeks. So when we often see these headlines about the planning systems not working, that's probably not entirely fair. So that's the first one I want to just jump up and down and say that probably deserves more of a pat on the back rather than the criticism we saw in the press. And secondly, praise the court system for operating properly in the way that it has. And as I said, shout out to all the public and private sector organisations and individuals, some of whom have been furloughed and therefore sitting on the sidelines, frustratingly trying to get back into the world, but some of them trying desperately to keep us on the economic and social track. So shout out to all of them, frankly.
Absolutely. Just on the issue of virtual planning committee hearings, Ian Alcock's asked a question, which a very, very good question, which I've heard asked by others in recent past, which is, could a virtual process expose the local authority to greater chance of JR? Well, subject to any issues with their constitution, which obviously if the constitution, the wording of it precludes in some shape or form a virtual process, that needs to be looked at plainly before they make a decision. Subject to that, my own view is I think the court's going to be pretty sanguine about this, because fairness has to be looked at in the circumstance. That's very clear from the common law authorities. And the circumstances right now is that we have to engage in physical separation. And so therefore, all you can do is the best that you can. And I mean, a good way of litmus testing a JR complaining that a virtual process is unfair is that the planning court itself would be hearing that JR remotely. because that's what it's doing. Mr. Justice David Holgate has just completed today a 2-day, very substantial planning court hearing, and it worked, so I'm told by one of the advocates in the case, Richard Turley, pretty well. It's not a promising start for somebody complaining that a remote process is unfair if they're having to complain about that to a planning court, which is itself operating remotely. So, Chris, expand on that regard.
Well, I think, my view is that you have to look at the nature of the complaint. How likely is it that somebody who complains will not have had the main part of their complaint or their objection dealt with by the process? So, just because one individual doesn't have their complaints about highways dealt with doesn't mean you've got good grounds for judicial review. It will almost certainly have been taken into account. And I completely agree with you, Charlie, that the court will look at this in the circumstances we're in now, and there shouldn't be a nervousness about this. There should be real confidence because the government has legislated to let this process happen.
Right. And that takes us quite nicely onto our next piece. And Sasha, plea of the week.
Yes, a plea of the week. Everybody on this webinar, or not that you allow me to call it a webinar, but everybody on obviously has an interest in probably the major cog in the planning system, which is PINs. And I do want to make this plea of the week in the context of what all of us in our personal and professional lives have faced in the past 8 weeks has been unlike anything we've faced before. So I give an enormous amount of latitude and understanding to PINs. But I think my plea of the week is a general recognition throughout the planning industry in the UK that we do need a bit more certainty, and we need more certainty in the near future, because what we've had are 3 pronouncements from PINs since the lockdown, and I do think that it would be enormously helpful, and that is why it is a plea rather than a criticism, but a plea that the powers that be at PINs really do try, as a matter of urgency, to get out a timetable for determination of appeals and a process for determination of appeals that takes into account the interests of third parties, the development industry and local planning authorities in an incredibly timely manner. I think the whole planning system would be incredibly grateful to receive some certainty in that regard.
I echo that, Sasha, and a couple of. It seems to me that clarity is the critical thing we need right now. We know PINs are piloting a limited number. I think it's no more than 8 remote hearings and inquiries. I think that they're going to start in late May, give or take. But what's not yet clear is what happens then. How long are they going to review that pilot? Against what criteria, and then are they going to roll things out wholesale after that, or only in relation to some cases or other, and over what period? And so we're standing here, and I had a video con with some developer clients yesterday. I think some of them and the team are on this call now, and we were looking at putting an appeal in for something, and they say, well, when's the inquiry going to take place? Heaven knows, frankly, right now, because we don't know how long the backlog is. Plainly, it will be behind the queue that is increasing because all the stuff that's been adjourned in April, May, June. And if we are allowed to meet in person, therefore, it's going to be behind the queue. If we are doing remote inquiries, are they going to be up and running wholesale by then? And so a little bit more clarity as to what's likely to happen and when and on what basis.
And one other point, Charlie, I actually make the plea, frankly, on behalf of the inspectors, because all of us in our communications this week, collectively, the 5 of us have all got appeals at all sorts of stages and all forms of determination. The people who are really struggling, in my judgment, are the inspectors who are having to make subjective judgments on how to deal with particular appeals in particular circumstances. And they're coming up with understandably different solutions and different expectations and guidance as how the appeals will be determined. So I think that reinforces my point that a bit of clarity, certainty would be of enormous benefit. Mary, is that your experience as well?
Well, I think there's a lot of frustration for those of us who have got dates in May, in June, September. We don't know where we stand. Are we going to get bumped off? And the people who lost out last month, this month, are they going to get put in? There needs to be some more transparent, I think, management. We all recognise that. I'm sure they're trying to do their level best, and I recognise that it's more complex for the planning inspectorate than it is for the courts. The courts are by and large dealing with litigation between two main parties, sometimes three, whereas the inspectorate are dealing with cases which involves potentially many more third parties. So I get that complexity, but I still think the messaging needs greater clarity, because confidence in the system is key.
Right, just can I add something there? Because I've had experience of two, one which is going to be in May and one which is going to be in June, where there's such a difference. The one in May, the inspector has largely decided to revert to a written procedure, and then will consider, after the evidence is exchanged, the idea of having some hearings. I don't see, and having already decided to inquire, I don't see how reverting to a largely written procedure is advantageous over using technology like this, even if it isn't perfect. If you want engagement in the process, that's a Secretary of State case, then surely this is better than something that is, it may not be 100% perfect, but it's obviously much better than just reverting to putting Secretary of State cases, important as Paul's has explained in his case, the value of cross-examination, just down to written reps. The other one, really interesting this morning, the council very positive in Lancashire, and they have already booked a venue for the inquiry, which can take 400 people. They're looking to have social distancing during the inquiry, and then looking to have a live stream for those who need to self-isolate. So a really positive attitude, and really, really welcome by the inspector, who I won't name, but it was great.
Thanks, Chris. A couple of comments. Nick Lee, who we mentioned earlier, he's asked you, Chris, if you've taken all the Seashell Trust papers from Paul and put them in your office behind you, and that explain all of that, along with, I suppose, all the stuff behind me. But seriously, a serious question he raises was, how well would inquiries work for difficult inquiries? How well would they work overseas? My own view is, plainly, there's no substitute for being in person. But they can work. I mean, I did to test it out. I had a sort of half planning, half competition case I did in the Chancery Division. Not an easy case, 2 silks on each side in January. And we still had the papers. So we did that with some colleagues of mine at Landmark and with a law firm. We did that as a mock remote hearing in front of Lord Carnwath, who just retired from the Supreme Court. And everybody involved, Lord Carnwath from the judge's perspective and all the other lawyers, felt it worked all right. Wasn't as perfect as in person, but as somebody who's now argued that case both in court and remotely, so have the experience of both, was anything really lost by doing that sort of case remotely? I'm not so sure it was. Somebody else has asked, will remote inquiries be used in future even when we're not restricted due to COVID? It seems fairly likely that PINs are looking at ways of using tech, but I don't think that it's going to be there as a replacement in person. It seems to me to be more of an enhancement, so something that would be used in addition. So, for example, if you were a third party who couldn't attend an inquiry in person due to family commitments, work commitments, mobility issues, you might be able to participate remotely, which would mean that you have a greater participation than now, but not at the expense of an in-person inquiry. It seems to me it would be a bolt-on.
Can I just pick up on that, Charlie? I agree with that we may see some innovative use of technology, which brings me back to the issue of the pilot schemes and what PINs are doing at the moment. I think initially, when we first had lockdown, there was a fear that this was going to be indefinite, and the hope was that sooner rather than later, we could have, during the course of lockdown, hearings which were taking place, inquiries that were taking place, to keep the system running during an indefinite period. We're now, I think, looking at a time when we won't just have the doors unlocked, but where we'll have a steady reduction in the restrictions that we're living under. And what we need is not just a pilot scheme in terms of how to do it whilst we're all in this situation, but how we do it in Chris's situation. I had a CMC this morning with PINs where we said exactly the same thing, that we need to have an ability to look after witnesses who can't come because they're still isolated. People who may wish to come but are still isolated, and therefore facilitating live video links, facilitating social distancing, are practical things that ought to be capable of being overcome. The issue is we should be working together, all parts of the industry, PINs, the authorities, and the developers and the land promoters.
Completely agree with you. Mary, you wanted to add something?
Yeah, the other thing I was just going to say was, don't forget also, local plan examinations. I mean, I personally think that this is going to go on for a while, that we are not going to suddenly return to where we were. I think there's going to be social distancing of sorts for some time, and I'm sure it's right that there'll be a combination of measures going forward. But I think the other important thing is to make sure that the development plan system doesn't grind to a halt, and to ensure that, again, advantage is taken of both technology and also oral hearings with social distancing and perhaps a more limited number of parties being invited, so as to ensure that the local plan system continues.
Absolutely.
Same with neighbourhood plans.
Our witching hour is approaching, so we're going to move on to our final topic. What's coming up in the next week? Mary, do you want to kick us off with your thoughts on what we might be addressing next week, what we might be seeing in the planning news in the next few days?
Well, I'm interested now that Parliament's back and, again, leading on the forefront of the use of technology. One of my thoughts was what's happening to the Environment Bill. I mean, remember this. We had the first and second readings in October last year, and then it got shelved along with everything else on the 6th of November when Parliament was suspended. I mean, those are the days when we were all using the B word, Brexit. Whatever happened to that? Right. How life's changed. Wow. But hey, I'm interested to see if the committees get going in Parliament and that bill continues to progress. So that's one thing.
Couple of legal cases that may need discussion. At least a couple of you asked already on the Q&A about the Corbett and Cornwall case. That was a case where the Court of Appeal looked at the principle that you can comply with the development plan as a whole, even if the development has conflicts with individual policies. And I posted something on LinkedIn about that. Extraordinarily got something like 10,000 views, which rather indicates the importance of that principle. And in my view, a principle that's not actually applied as often as it should be by people on all sides. We may well have to look at that in a bit more detail next time under the court case of the week. The Heathrow permission to appeal decision, I mean, not been a great time for airports and those in the aviation industry, but the Heathrow expansion application for permission to appeal to the Supreme Court is due imminently. The Supreme Court's started its new term this week. I wouldn't be surprised if we get a decision one way or other on whether the issues about the Paris Agreement's relevance to the UK legal system are going to be explored by the Supreme Court, and then we'll know after that when the Supreme Court's substantive hearing is going to be. Chris, any thoughts from you about issues that are likely to be hot potatoes the next few days?
Well, I think we're all waiting, and we believe very shortly we're going to see the North Essex Authority's local plan report from the EIP. That was, if you remember, a very large new settlement across 3 authorities. That Inspector Roger Clues was not impressed with the evidence supporting that. And yet we know government is hugely enthusiastic about new settlements. They want them to happen. But sometimes, the evidence, inspectors feel the evidence isn't there. We're expecting that report. The inspector gave them effectively a second chance, and we'll be seeing whether he has accepted the revised approach.
As somebody who spent 3 weeks in January promoting one of those communities, I'm hoping I'll have some bragging rights, as Paul did this week, on that one, if that goes well. There's obviously also something we'll need to discuss next week is St Albans. Obviously, the decision in relation to their plan came out today to much fanfare. Not good news for St Albans Council, and something we'll have to chat about. Last point,
Charlie, we won't mention Landmark's involvement defending that plan.
No. Thankfully, none of us involved.
Can I mention 2 things, Charlie, before we go? As I said, I'd like next week, I think it'd be topical for us, 2 of us to take the side of the LPAs and 2 of us for the development industry on discussing the HLS, what we should do with HLS in the light of 3 to 4 months non-delivery and trajectory. I think that would definitely be worth making. Can I also give a shout out to Kieran Rafferty, who suggested, and I completely commend him, that written reps are changed into video hearings in future. I think it's a fabulous idea. 1-day hearings by video, those matters which are currently dealt with by written reps.
I think that's a great idea. Thanks for that, Sasha. Thanks, Kieran. Lots of you have asked questions. We have something like 52 questions. Clearly, we haven't got to deal with all of those. We'll, if the technology permits, and I think it does, we'll try and answer as many of those as we can afterwards. Quite a few of you asked for details of the cases we've referred to. What we might do is just do a little LinkedIn post for those of you on LinkedIn with either links to the cases or details of them, so you can look them up. And please do use that Q&A facility or email any of us going forward between now and next week, so that if there's any issues you'd like us to discuss, then we can look at that and discuss them next week. So it will be the same time, same place, or same places, including Hogwarts stroke the Seashell Trust book depository in Chris's case. Thursday the 30th of April, 5 o'clock. And we hope that as many of you as possible, and if not more, can join us then. Thank you very much. We hope you've enjoyed it, and please don't forget that link to donate to the NHS if you so wish. I'm going to end this meeting now, and enjoy the rest of your gins and wines. Have a great evening, everyone. Cheers.
Cheers.
Bye.
Cheers.
Bye.
See ya.
Bye.